Okay, hi everyone. Welcome to Miller Johnson's 5-minute message. This is regarding Marsh updates. My name is Eric Feldman. I'm attorney at law at Miller Johnson, in which I practice in the educational unit. We'll be talking about the Michigan Administrative Rules for Special Education updates, or Marsh, M-A-R-S-E. It wasn't a massive update. It had three general rule updates. So under Rule 1721B, the Michigan Administrative Code. This generally applies to what you do when you receive a written request for an evaluation when it's made for a student attending a public school. Generally, the rule says within 10 school days of the written request, the public agency shall provide the parent with written notice. And then after that's done, you have to get consent by the parent and you have to determine eligibility within 30 days of that time frame, and on and on and on. It has all these time frames, and if the parent disagrees with it, they can file a due process request, etc. The point of this rule was they basically added a section of how you handle when a written request for an evaluation is made when a parent places a student in a private school. So that was never done in there. And that was actually, they codified that from the CFRs, from rules 34 CFR 300.130 to 300.147. So basically, in a nutshell, what they added was they made a process for determining eligibility for special education for parent-placed students in non-public schools. So that right was there already, but it was in the CFR section. They just basically codified it, made it in Mars, and now that the public agency, they have to act now if they get a request for students placed in private schools. So it's what I take away from this rule is make sure you have relationships, for example, with your parochial schools, for example, so that if there is a request for an evaluation or initial evaluation, excuse me, you can start that process. Within 10 days, you got to provide notice, got to get the written request, and then within 30 days, you have to determine eligibility, etc. So just what I get from that rule is basically have a process in place so that you can determine initial eligibility within the applicable time frames. Under Rule 1723C, this is a little more important as in terms of what they changed, but 1723C talks about the rights for independent educational evaluations. So here in the original rule, they basically stated that in order for a parent to request an IE, it had to be in writing. Well, they removed that. They basically said they removed the requirement and they made it consistent actually with the CFRs. They require less in terms of when you request an IE. So it could be oral. The parent could say you could have a meeting and they could with the IEP team, and the parent could say, I disagree. I want independent evaluation for whatever it may be. And then you have to process that request. So no more writing requests for IEs. What I do recommend for anyone in the special education unit or whoever it may be, still do it in writing in terms of acknowledging receipt. So I would send an email or whatever it may be saying, dear parent, on such and such date, you requested an IE, you did a verbal request for IE, we acknowledge receipt, and we'll get, and then you'll respond to them. And usually you have to respond within 7 days, indicating whether you intend to honor the request or initiate your hearing procedures to disagree. The final rule is a little different, but basically they modified Rule 1733 to require that the age span for students who are assigned special education programs, except for severe cognitive impairment and serve multiple impairments, operate in an elementary building. So age span does not exceed the age span of students who are not disabled in the building. So that one is not as much, but make sure having the right age requirements in there in terms of the programs. So this has been the 5-minute update. I appreciate everyone joining today, and I wish everyone a wonderful day. Thank you so much.